but today the Supreme Court ruled it unlawful. Now let's examine why they ruled it unlawful. And before we do that, we have to speak about something called the European Convention of Human Rights. Now, this was an international treaty which Britain signed up to in 1951, and it came into effect in 1953, and it involves well over 40 countries throughout Europe who are all signed up to this document, and this document is law. Now, the ECHR, as we're going to call it, is to be distinguished from, is to be differentiated from the European Union. It's not a part of the European Union as such. So when we left the European Union, we were still subject to the European Convention of Human Rights, and we still are subject to it. It is our ultimate human rights law. Now, prior to 1998, you could claim your human rights under the ECHR, but you'd need to go to the ECHR court, which was in Strasbourg. So in 1998, the British government at the time integrated the entire ECHR document into British law, and they called it the Human Rights Act 1998. So what that meant was that your European human rights were now directly justiciable, and you could appeal them directly here in the UK. So we've basically got two laws which are very similar, which are almost the same. The ECHR, which is in Strasbourg, which is the ultimate one, and the Human Rights Act 1998, which is the British one, which mirrors the ECHR. That's the situation at the moment. It means that people can claim their human rights directly here in the UK through an appeal to the Human Rights Act 1998. Now, but let's concentrate on the ECHR, the main one. And there are two articles in that which people who are immigrating or people who are going to be deported can appeal to in order to stay in the UK. One of them is Article 3 and the other is Article 8. And those are really the only two articles in the ECHR which affect immigration and asylum and deportation and extradition and so on. And Article 3 says, no one shall be subjected to torture or to inhumane or degrading treatment or punishment. And Article 8 says, everyone has the right to respect for his private and family life, home and correspondence. And as I say, claims to stay in the UK are always made around those two. Article 3, which is about inhuman punishment, and Article 8, which is about family life. Now, Article 3 is the one that we're concerned about today because it has for many years been interpreted in a very broad way by the courts. It's been impliedly interpreted, which is to say, it doesn't say so in as many words, but it's been stretched to mean other things. And although it says no one shall be subjected to torture or to inhumane or degrading treatment or punishment, that's been stretched to mean that you cannot send an asylum seeker back to their country if there is the mildest suspicion that they might be subjected to that sort of degrading treatment or punishment or, at worst, torture. So if there's the faintest suggestion about that, then you basically have to allow them to stay. And that's the one that the courts were concerned about today as well, because it further means that if you send them to a third-party country, such as Rwanda, which then sends them back to the country that they came from, and from which they claimed to be fleeing persecution, then this would also be against Article 3 of the European Convention of Human Rights. And so, to get over this, what the British government did in 2004 was it created the Asylum and Immigration Treatment of Claimants Act 2004, and in that they listed all the safe countries that you could return people to. And Schedule 3 lists the safe countries, and Schedule 3 states, a state to which this part applies is to be treated as a place to which a person can be removed without their convention rights under Article 3 being contravened, and from which a person will not be sent to another state in contravention of their convention rights. And so there's a big list of places, and like France, Switzerland, countries like that, okay? And guess what? Rwanda is not included. So Rwanda is not considered a safe place in the Asylum and Immigration Act 2004. And so that's a glaring loophole. So they basically said, let's all send people back to Rwanda, but let's forget to add Rwanda to the safe countries list. So you have to wonder, was that deliberate almost? Because that's such a glaring loophole in British law. Anyway, what that meant is that the 5 judges today ruled the policy was unlawful because of the risk that asylum seekers sent to Rwanda could then be returned to their own country and could therefore face the problems listed in Article 3, the persecution of their human rights. So what you've got here, and this is an interesting point, is the court today made a political judgment. They made a political decision about whether they think Rwanda is a safe country politically to send people to. Based upon what? Well, based upon what they know, based upon what they've read, based upon what they've seen, based upon what they've heard. Not based upon the black letter of the law, but just what they think politically. Because the government hasn't clearly listed Rwanda as a safe country in the Asylum and Immigration Act 2004, and so the judges themselves have to decide whether or not Rwanda is safe, and they've decided politically, not legally, politically, that it's not safe, and therefore cannot be a place to send these people. And they should not really be doing that, because they made a political judgment there, not a legal one. But, well, they were free to make that political judgment because the government had not made that political judgment for them and had not written it into law. So, the judges have made the decision that Rwanda's not safe, and it's an entirely political decision which is not for them to make. So what's our position on that? What should be the correct thing to do? Well, our position is that Rwanda seemed a slightly wacky idea in the first place, but if we're going to continue it, then the first thing that needs to be done is that the word Rwanda, and we'll spell it for the government as well if they have trouble, but the word Rwanda needs to be added to the safe list in the Asylum and Immigration Act 2004. And then once that's done, if it goes back to court, then the lawyers will look at it and they'll say, oh, holy moly, Rwanda's a safe country now. Yes, you can send them to that. So that's the very first and simple thing. If that's ever going to get done in time for the next general election, we'll have to wait and see. It could, of course, be done overnight if the government actually wanted to, because the government can do anything overnight if it wants to do it, as we saw with the situation back in 2020 when they brought in emergency laws. So secondly, that's the first thing they need to do. Secondly, we are essentially facing an emergency. There's hundreds of people coming over the channel every day. Nothing is being done about them. So it really is something for emergency legislation if there were to be a party and a government that had the cajones to actually do something about it. It could be done. It could it could be sorted very easily. What needs to be done? Well, the first thing that needs to be done is the law needs to be sorted. And then the second thing that needs to be done is once you've sorted the law, you get to physical action and you get to stopping people and you get to removing people. But you cannot engage in the physical without first having the legal right. So how do we set the legal right? Now, Suella Braverman suggested this in her letter to Rishi Sunak yesterday, and we've got page 1 of her letter, which we'll just bring up here because there's something in it that I want to highlight to you. And she wrote a three page letter, and let's bring it up. Here we go. Now, I don't know if you can see that very well, but she lists 4 paragraphs there at the bottom. And in number 2, she says one of her things that she wanted Sunak to do was to include specific, quote, notwithstanding clauses into new legislation to stop the boats. That is, exclude the operation of the European Convention on Human Rights, the Human Rights Act, and other international law that has thus far obstructed progress on this issue. Okay, include specific notwithstanding clauses into new legislation. Okay, so what does that mean? What that means is that a government that is faced with a previous law that is going to make its policy difficult can simply put in a clause to a new law that says, notwithstanding Article 3 of the European Convention of Human Rights. And what that does is it disapplies that article in British law. It means it has no more effect on that particular matter. So they could bring in a new law tomorrow, the Rwandan asylum law, and the first paragraph could say that everybody's going to be deported to Rwanda, notwithstanding Article 3 of the ECHR or Article 3 of the Human Rights Act. And that would mean that those articles don't apply in this situation. That's what Suella Braverman means there by notwithstanding clauses. They disapply previous law for a particular policy that needs to be carried out at the moment. And it's perfectly legal, and it's been done before on other matters, and it's just a normal constitutional thing that countries around the world do when they need to disapply a particular law in order to get a particular policy done. Only one problem here, and the problem is you're not allowed under the ECHR to disapply Article 3 or Article 8, and if you do disapply it in your domestic law, then it means that you are basically leaving the ECHR. And so you can't actually make a notwithstanding clause and relate it to either Article 3 about torture or Article 8 about family life without actually saying that you're effectively leaving the ECHR. Okay, so notwithstanding clauses don't work with the ECHR. You literally have to leave the ECHR before you can do that. So that's the first thing that actually does need to be done, is you need to leave the ECHR. That's the first legal thing that needs to be done. Now, what that will leave you with, of course, is the British domestic law, the Human Rights Act 1998, and that act you can disapply as much as you want. So once you've got rid of the ECHR, you'll be faced with the Human Rights Act, and you can, if you wish, disapply elements of that in any future law. That's perfectly acceptable. So those are the first 2 things that need to be done, and they do need to be done if you're serious about stopping immigration and if you're serious about creating a law which will allow you to do what needs to be done. You firstly need to leave the ECHR, and then you need to, where necessary, apply notwithstanding clauses to the Human Rights Act. Now, once you've done that, you will be legally able to go ahead and do what you need to do physically. And that's where it's going to be a big fight, because the Home Office does not want to stop immigration. And I would suggest that, in fact, the Home Office Department for Immigration and Asylum needs to be scrapped. And the only way you will get a culture that wants to address the problem will be to basically contract it out to an arm's length private organisation that is doing it for financial incentive. That's the only way, because the present British state at Whitehall is not going to stop immigration or asylum. So that's the first thing that needs to be done. And then once you've done that, you can build up the border force, you can stop people in the channel, you can drag boats back, and you can physically return them to France, and you can do all those sorts of things. But until the culture is addressed at Whitehall, then nothing is going to change physically. So the legal things are leave the ECHR and then disapply elements of the Human Rights Act. And you can, once you've done that, once you've cleared the legal path, then you can get with the physical actions that are necessary. But make no mistake, what I am talking about here is a revolution, an absolute revolution in thought, because there's no way the establishment at this time will do any of these things. That to do these things is to totally overturn and sweep away the orthodoxy which has been in place in the West, and especially in the UK, since the end of World War II. Okay, the end of World War II brought in a whole new post-war settlement, and things like the ECHR and all of these things come from that. And to overturn any of that, to leave the ECHR, that's a massive revolution. And it's only going to be revolutionary people and parties that will carry that forward. Because it is the people who want to keep the post-war settlement in place will scream. They will scream if you try to do that. But I think we are entering into a period now where these things are becoming possible, because more and more people are asking, how on earth did we get to the place that we are in? How on earth did we do that? And it's because of all these post-war settlements and all the ideas that came out of the post-war that are in place, and which now no longer function. Now no longer function because the world has moved on technically, and those things now need just to be swept away and new systems to come in. And I can see that happening. So that's a positive message, that at the moment it looks pretty bleak, but we do know what needs to be done. But what needs to be done is a revolution. Now I did bring up some of these ideas in a booklet that I wrote many years ago, called How Britain Lost Control of Its Borders, and that's available at our shop. We'll just put up the link there. And I really need to update this, because this was written prior to us leaving the European Union. This was written back in 2009. So let's put the shop banner up there. There we go. Good.